From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday at 5 o'clock. That means you are listening to FLALAW on the radio. My name is Matthew Noyes. I'm one of the attorneys at the law firm of Perenich, Caulfield, Avril, and Noyes, the oldest personal injury law firm in Tampa Bay. We started 70 years ago. That's right. We are celebrating our 70th birthday this year. Guy Perenich started our firm in 1955. And we have been going strong ever since. We do personal injury. We do car accidents, slip and falls, trip and falls. We also do work injuries, workers' compensation, and also Social Security disability. I'm here to answer any questions that you have regarding those areas, but I also have a special guest, my friend and my colleague, Jake Blanchard. Jake is here, taking an hour of his time to give back to you all regarding his areas of law. So, Jake, why don't you introduce yourself and tell our listeners what areas of law that you can address tonight?
Sure, Matt. I am Jake Blanchard of Blanchard Law. I have been a licensed practicing attorney here in Florida since September 2008. I practice primarily in the area of bankruptcy and business law, and sometimes at the same time. I do a lot of consumer bankruptcies and small business bankruptcies and reorganizations, and along with that comes, business and business litigation. But I really sort of consider myself a bankruptcy geek because that's the area of law that interests me most. That's for sure.
Yeah. And Jake, I think we've known each other, for way back. I know when you had your office right on Belcher, Belcher Road back there as well. So it's been a while since we've known each other.
Yeah, many years.
So Jake is here to answer questions regarding bankruptcy and business law. And I'm here to answer personal injury questions or Social Security disability, or even work comp questions. And if you have a question regarding the law that's not in our areas of law, we can play baffle the lawyers, and we can try to tackle the questions that you have, or at least give you some guidance. So how do you get your questions asked? How do you get them over to us? Well, there's really 3 ways that you can do it. 1, you can call us. We're here live in studio at 727-441-3000. Again, that's 727-441-3000. You can call us and ask your question here live on the radio. A second way to do it is we are also live on Facebook. Our firm website, Perenich, Caulfield, Avril, and Noyes Injury Lawyers, our Facebook page is currently live. You can see us right there. You can see Jake and myself here in the studio, and you can type in your questions and ask your questions via Facebook Live as well. And the third way to do that is through our YouTube channel. We are live also on YouTube on Perenich, Caulfield, Avril, and Noyes Injury Lawyers YouTube. Just search that. You'll get us live on YouTube as well. You can type in your question, and good old Ed over there on the other side of the glass will shoot us a little message and let us know that you have a question. So there's 3 ways to get in touch with us. Again, telephone, 727-441-3000. Facebook Live or YouTube Live on the firm's website at Perenich, Caulfield, Avril, and Noyes Injury Lawyers. So we're here for an hour, so please give us a call or send us your questions. But Jake, before we even talk about bankruptcy and the law, I have to do my little research before the show every time. And
sure.
And sure enough, something popped up, and I thought that maybe, just maybe, I'd ask you about it, because although you are a very fine bankruptcy attorney,
thank you.
He's looking at me saying, "What are you going to ask?"
What's going on here?
I also have found, and I saw some photos of you being a very fine dancer as well.
Oh goodness.
Why don't you tell our listeners, your dancing skills over, I think it was this past week, right?
Oh goodness.
Should we roll the video?
No video. This is a radio show. Apparently that's out now. So my daughter has been dancing at Totoro Dance Academy. I think she probably just after she started walking. She's maybe like 2.5.
How old is she now?
She's 14.
Okay.
So her name's Mara Blanchard. She's dances competitively for them. And so I help out with, the props and stuff like that. I'm the, one of the dance dads. And so the dance dads have a dance, but it's not, when I first said something like that to my buddy, he's like, oh, so you go to the dance with your daughter? Like, I was like, no, it's like
you got to get up on stage.
It's like 30 dopey dads just sort of bopping around to in some sort of unison to music. But so we had the recital last weekend, and there was 3 shows, and so we did the dance dance 3 times. And it was the first time. It really is kind of like scary though. I did feel like butterflies in my stomach. But my wife grew up dancing at Totoro, so it's important for me to make a good showing. So she trained me with the moves and things like that.
And you were good enough because she posted your photos on
Apparently,
Facebook.
I hadn't seen them yet. Maybe I should go look at that.
Yeah.
So. But I hadn't expected to talk about that. But yeah, so it was a lot of fun though. I mean, anytime you can do stuff like that, and I coach soccer for my son, and I do the dance dad stuff for my daughter, and they're very appreciative. And so and that's the best. That's the best. Being a dad's the best.
That's exactly true. I have 2 kids and 2 granddaughters, so I understand it. And I wanted to let their listeners know that because you're a great attorney, but this shows that you're even a great guy as well. And I think it's important that clients have attorneys who they can trust, who are similar to them, have like experiences and such like that. And so you being the dance dad and the prop dad, I think really goes a long way to let our listeners know.
I appreciate that. So, and it's a lot of fun, and I enjoy doing it. It's, but it's nothing that there I am. Oh my goodness. I saw it. Okay.
You saw it.
Yeah. So that's funny.
So next month, when Jake comes back for the next radio show, we may have him in a soccer goalie, a soccer goal blocking kicks for his son's team or something like that. Huh?
Man, I don't know. There's some of those kids that they're, even though they're 14 years old, I do not want to get in the way of some of those shots. Those kids are really strong these days. I don't remember being that big and strong when I was 13, 14 years old. So
no, it's crazy.
Yeah.
Well, so let's get right into your area of law then. All right, Jake?
Sure.
We talk it's bankruptcy, but let's start simple. What exactly is bankruptcy? But more importantly, what is not bankruptcy?
Well, bankruptcy it's an insolvency law, and it's rooted in the Constitution. It's actually I'm not a very religious person, but I see the Bible over there. And there's at least 3 places in the Bible where it says the forgiveness of debt is good. And I believe there's like a reference to on the 7th year that was forgiven or something to that extent. So bankruptcy and debt forgiveness have been a facet of our civilization, going back for as long as
Bible times. I didn't even know it was in the Bible. That's really cool.
So the concept is a fresh start now. And it is a fresh start for the honest but unfortunate debtor. And there's many varieties of bankruptcy. The most common is consumer debt, where people have lost a job or have gotten sick and then supplement the income with credit cards and get behind on car payments and things of that nature. And for that type of bankruptcy, not too far from the Bible verse where it says every 7 years, you can only file what they call Chapter 7 every 8 years, and it's a straight type bankruptcy. There's other types. There's a repayment plan depending on the circumstance. But I believe it or not, I beat myself out of attorney's fees by telling people this, but I think bankruptcy should be a last resort.
Oh, yeah. Why is that? Why do you think it should be the last resort instead of someone who's just having, a temporary stressful time of bills and such like that, and maybe have lost their job, but about to secure another job? Or why would bankruptcy be the last resort?
Well, and when I mean last resort, I mean there isn't a better option, right? So at some point, if you're drowning in debt, you look at your options, and that's what I tell people when I give them a consult, and I get free consults every day. And when I look at the situation, I give people options. So,
Okay.
And when I say last resort, we'll talk about the options, and there really isn't a better option. You sent me a list of questions that we had, joked about, answering. But one of them is, have you ever talked somebody out of filing bankruptcy before when they didn't actually need to do it? And yes, in fact, I have. And I would say probably once a week, I probably talk somebody out of filing bankruptcy, because it's not something you want to go into lightly. And like I said, you can only do it every 8 years. It's one of those things too, where if you're a car accident attorney, right?
That's
So
right.
for me, the analogy, if I'm using an analogy for a credit report, because having bad credit's expensive, but sometimes you can't help it, obviously. And sometimes you need to, just rebuild it. So, but initially when someone files bankruptcy, if you could think of like a car accident, if you miss a credit card payment, go beyond 30 days, that's a dent or ding in the fender. You go 60 days, you tore off the back end, you go more than that. Then you got some
cracked windshield.
you got some significant front end damage. You go, you file bankruptcy and the car's totaled, right?
Okay.
So but you can still rebuild it.
Right.
And so there's a lot of things that people can do post bankruptcy to rebuild their credit. But sometimes, like I say, if the situation can be fixed and credit is important to you and your credit report is important to you, and it should be, like I said, not because I think everybody should run out and get credit cards, but at some point, if you want to buy a house or you do need a car and you do need a loan, the better the score, the better the rate.
Right.
So it's expensive to have bad credit, but sometimes you can fix it without bankruptcy. Sometimes you just got to wipe it out to start over, though.
What are the most common reasons why people do end up filing bankruptcy?
I think the most common reason that I always see is a psychological pressure. I say that people, from a legal standpoint, have legal pressures, and from just a life standpoint, have psychological pressures. We all do. And the psychological pressure that leads people into filing bankruptcy really relates to having a certain amount of debt. And you're just making the minimum payments, and the minimum payments you're barely making, and the interest is just still, it grows, and the debt is growing and growing and growing, and it's a hole you can't dig out of. And some people get to a point where they can't sleep at night, and they need to make a change in their life. And so a lot of people, for psychological pressure, they come to bankruptcy so that they can get a fresh start.
Right, but it's not always people that run up credit cards and they were carefree and didn't really care about their credit, and they just took advantage of the high credit limits. And And now they have too high credit cards that they can't pay off. That's not always the situation with bankruptcy.
And I mean, obviously the response that I'm going to give isn't like a scientific, statistical approach, but it's anecdotal.
We won't hold you to it.
All right, but no, but
Spoken
I've been
like a true lawyer. Did
but
you
it's
hear
still,
that? All?
but yeah, but that's just a disclaimer there. But I mean, in my experience, it's actually not like people think. I would say the majority of folks that file bankruptcies because they got sick. Like people don't realize this, but bankruptcy is a big part of our healthcare system.
Yeah. Okay. Explain that. What do you mean by that?
Well, if a lot of people get sick, they don't have disability insurance. A lot of them don't have health insurance.
Right.
So they will end up in an emergency situation relying on their credit cards because they're sick, they can't work. They got cancer, they can't work. So they'll use their credit cards. They'll use their credit cards to pay the doctor bills so that they can continue to go to the doctor. So eventually, when the credit cards are maxed out, and they're at the end of the rope, and they've got so much in credit card debt that they can never possibly pay back, that the bankruptcy system is there, and it really is sort of has a bit of a crossover with the healthcare system.
Sure. And there's sometimes that these people that get their medical tragedies or situations that they don't even have credit cards, so they can't even rely on that, and so
Right.
their medical bills just keep piling up.
Yeah.
And then they're stuck.
Right.
And they have hundreds of thousands of dollars worth of medical bills
Right.
that they have to deal with.
I mean, and I do, and I see that a lot. And the other thing is with the job market. I mean, there isn't anything. I don't think there's anything that's economy proof. Someone once told me that being a bankruptcy is economy proof, and I'm not so sure of that. Right.
Yeah.
And I also don't predict the economy. Like I have people. One of your questions was, do you go to a party and do they think you're a divorce lawyer and do you run?
I even crossed that one off. I didn't think I was going to ask you that one. So.
Well, that's the one I would tell you, and I do. But but inevitably the party question I get as a bankruptcy attorney is, what's the economy going to do? And I have no idea, and I stopped trying to guess.
Yeah.
And it's because nobody really knows. I think that the time when you finally figure it out, it's probably too late, and then that person or whoever you're dealing with probably at that point felt the effects of it by losing their job, and then having to fall back on credit cards to make ends meet.
Right. Or the sun comes up and the economy that was yesterday is different than it is today, and it will be tomorrow. So.
Yeah. I mean, there's nothing constant in life but change.
That's exactly true. You're listening to Jake Blanchard. I'm Matt Noyes. We are two attorneys here on FLALAW on the radio. We are here to answer questions that you have. Jake is a bankruptcy attorney, also a business attorney, so he can tackle those questions. And I am one of the partners at the law firm of Perenich, Caulfield, Avril, and Noyes, who are proud to provide this show every week on Tuesday from 5 to 6 as an opportunity to give back to the community to answer questions that you have regarding the law. So please, 3 ways to call us, 3 ways to get in touch with us, 727-441-3000, or jump on our Facebook Live at Perenich, Caulfield, Avril, and Noyes. You can see our ugly mugs here in the studio. Well, my ugly mug, Jake. Jake is not an ugly mug. Or you can go on YouTube. You can go on YouTube and see us there as well and type in your question there as well. So we are here for you. Jake, you are talking about the questions I sent. I said, let me give this AI a try. And so I just typed in, I think it was ChatGPT, and said, hey, give me 15 fun questions to ask a bankruptcy attorney.
I think even ChatGPT had a hard time with that one.
They spat them out, and there were some that I did cross off, but there were some. One of them that I thought was pretty good is, what's one mistake people make that you want to just shout no in slow motion?
That's funny you say that. I don't know that I can point to that in an individual consumer type case, but I can tell you in a business bankruptcy, business reorganization setting, when when that happens, and that is when they don't pay the employment taxes.
Okay.
That's the unforgivable sin. It's really hard to work through that after you have missed, more than a couple quarters, I would say, because the bankruptcy code's very strict about, paying those types of taxes, because they see that as what they call a trust fund tax. In other words, as an employer, you're withholding a certain amount of funds, and then you're supposed to give it to the government as, and match it. So if you withhold it and you don't give it to them, they almost consider it theft, right?
Yeah.
It's not. I mean, in extreme cases, it can be a criminal case, but nothing at the level that I'm at. But that's where I'm okay. That's a really expensive loan. You don't want to do that.
Yeah.
So, and the penalties and interest and things of that nature. And the IRS is different than, Bank of America, because they don't have to go through the judicial process to shut you down.
Oh, okay. The IRS can just shut you down.
Well, the IRS, but they can't necessarily shut you down. Well, they can, but mostly the way they do it. I mean, you occasionally hear the story of padlocks on a door,
Right.
or like at the warehouse when you get to work. But usually the way it happens is they levy a bank account.
And then you have no access to
Right.
your funds, and you can't have any operating expenses.
And it's just stranglehold. And so if you get to that point, that's there's there is a too soon and too late for bankruptcy, and for a business reorganization,
Okay.
not for personal really, but not a too late, but sometimes too early. Timing is everything. But at any rate, that's where the answer to the question is, like, do not miss that. Don't do, pay the government. They're the most brutal collection agency on the planet.
Yeah. Now, in our area of law, especially in the auto accident cases, the thing that we always want to say no when a client tries to talk to the insurance company about their claim.
Right.
They start trying to negotiate their claim before they talk to the attorney.
Right.
Do you have situations in bankruptcy where can people file bankruptcy on their own and then come to you and say, please fix this mess that I just created?
It's really hard for that mess to be fixed. I would never encourage anybody, no matter how simple they think the case is, to try to file a bankruptcy on their own. There's so many pitfalls and there's so many rules and procedures that even though you don't have an attorney, that you'll be held to, because bankruptcy is all about disclosure, and it's all about leveling the field between the creditors. And so a lot of people can get jammed up, and it's not like flipping a light switch on and off. Once you, especially for like a Chapter 7, once you file. And a trustee will get assigned to the case, and the trustee has an incredible amount of power to reach back in time to get what they would call fraudulent or preferential transfers. And the thing with a fraudulent transfer is you don't even need an intent. And it can be a constructive fraudulent transfer. And so those are also, I guess, to go back to that question where I say, no, don't do that. That would be one of them.
Yeah. And unfortunately, we see that way too often. And oftentimes it's too late.
Too late, right.
I mean, just last week I talked to a client who said, gosh, the adjuster called me after my car accident, and she offered me $5,000, but she told me I still had $10,000 left. And so she paid me the money, and I had to sign some form. Well, in essence, she just settled her case, and she signed a release before talking to us. And it's almost impossible to get out of there. And so it's always important to talk to an attorney. And you get free consultations.
Yes.
We get free consultations. So there's no reason why you wouldn't talk to an attorney before you jump into the legal arena, whether it's civil or bankruptcy for you.
I mean, exactly. I mean, it doesn't cost you. anything to get a consult. The consults are always free. The one thing that I would say, though, is that if you do the consult, make sure you tell your attorney everything, the good, bad, and the ugly. It's like going to the doctor and not telling the doctor something particular that might be embarrassing, but, they're not going to be able to help you if you don't, kind of thing.
Or not telling your personal injury attorney about the 3 other car accidents that they had 2 years ago.
With pre-existing injuries.
That's right. Yeah. Well, before we take any calls, I did want to, Jake, I wanted you to kind of walk us through what actually happens when someone does file bankruptcy. What's the steps that they have to go through, and timeline and such like that? I know every case is different, but just generally, what's this? So, what do they have to go through? What should they expect?
Okay, so generally speaking, most bankruptcies that are consumer bankruptcies, that are what most people would refer to as a straight bankruptcy, which is a Chapter 7 liquidation. The timeline begins with the consult. So someone will come in for a consult. We'll talk about their particular situation, and depending on the circumstances of the situation, I may recommend that they try something else before they file, or I might give them another option and then give them a choice, and then say, hey, come back. You follow up with me. I'm not a salesperson here. If you want to go forward, here's a follow-up email, and this is what we need.
All right.
So
no pressure, just information.
Right. So and so I'll send the follow-up email, and I'll have my typical retainer agreement, and I'll have a questionnaire. I wrote a short letter that sort of summarizes the timeline. Probably should have pulled that up to answer the question. But and then when in some credit course flyers. So one thing about bankruptcy is from consumer individuals. Individuals have to take a credit counseling course, and it takes about an hour and a half online. And there's a number of different companies that provide it. And
every applicant, everybody who's thinking about
all
bankruptcy
individuals, yes.
Oh, okay.
Yeah, businesses, they don't have to do the credit counseling course.
Okay.
So, and then actually you got to do a follow-up course, which is a debtor education course after you file. So it's like a physical in the military. You got to take one to get in and one to get out, kind of thing.
Okay.
So to get the discharge. So at any rate, so I'll send the follow-up email. In the email, has the questionnaire and a list of documents. So, there'll be like 6 months of bank statements, 6 months of pay history, last 2 years of tax returns, copies of mortgage statements or a lease or whatever. There'll be a list of documents.
Sure.
So once the person gets all the documents, and then we'll take that, and it'll take about, a week to turn it around into a bankruptcy petition. And a bankruptcy petition is accompanied by what they call a statement of financial affairs, current monthly income calculation, and schedules. And schedules are just really lists of stuff, like a list of property that you have, a list of your exemptions, the stuff that you're going to exempt from the trustee or the bankruptcy estate, like your homestead or retirement. And then there's going to be a list of creditors. And so on. And so the statement of financial affairs is all disclosures. So about your financial life, or probably, I would say, at least the 3 years prior.
Everything you need in order to guide them through it.
Correct. And so, and all the questions to the test are right there. So if you're going to have a problem, that's where that's where you should know. You don't want to find out when you file and then have a problem with the trustee. And then I'll have them come in, meet with me personally. I meet with all my clients. I don't have a paralegal or a legal assistant do the signing. My name's on the door, so I make sure it's perfect, to make sure the I's are dotted, the T's are crossed, and it's in ship shape. So we'll go through it, make sure everything is true and correct. They'll sign it, and then we file it electronically. And then about 25 to 30 days after that, so from a time point, from like a time spectrum, then you got about 25 to 30 days, you'll have that meeting with the trustee.
Perfect.
And then
I'm going to pause you just saying, because it looks like we do have a call.
We got a question from Steve on YouTube. Says you talked earlier about that you do talk people out of bankruptcy. Can anybody actually be denied bankruptcy?
Oh, that's a good question.
It is a good question. That's a really excellent question, because when someone's talking about being denied a bankruptcy, what they're mainly talking about is being denied the discharge, because the ultimate goal of someone that files bankruptcy is really twofold: to stop the creditor harassment initially, and then to be able to get a fresh start. So that fresh start, that is the discharge. And so, have people been denied the discharge? Yes, there are times where people are denied the discharge, and it can be from a transfer that was undisclosed, or it can be for a debt that was occurred through fraud or misrepresentation or something of that nature. So from the timing standpoint, going back to that, we have that trustee meeting. And then after that, there's a 60-day period where creditors can object to the discharge.
Okay.
And so,
because you have to put all the creditors on notice
that's
from
right.
that schedule that you had your client complete.
Correct.
Okay.
So there's a number of things that can be objected to within a bankruptcy to prevent a discharge for a certain debt, or even for the bankruptcy entirely. Mainly, it's fraud and misrepresentation, and another one is typically, mostly it's going to be like alimony or child support. That is on its own and not dischargeable.
Okay.
And another one is, very technical sense, like if someone's a trustee of a trust and they're in a fiduciary duty and they stole from the trust, obviously that sort of thing's not dischargeable. But the main common one is incurring a debt through fraud or misrepresentation.
Okay. And so the creditors, they have an opportunity to object. And if they object, then what happens?
Well, then what happens is that they'll file a case within the bankruptcy case.
Okay.
And that's called an adversary proceeding. And that adversary proceeding is basically a separate case that has a complaint that is very much looks like any other type of civil complaint, where it states allegations.
Okay.
And in that complaint, it'll lay out the allegations, why they think that you shouldn't be granted a discharge under the bankruptcy code based on the actions that brought you to the case.
And does the bankruptcy judge ultimately make that decide that case inside the case at the time of discharge?
Correct. Yes.
Okay.
Yeah.
All right. And so
and that's litigation. I mean, essentially.
I mean, you're taking depositions and
discovery,
and all the discovery, and it's not just filing paperwork and going. You're doing all the heavy duty work,
right?
Okay.
And so, and if you're going to get into that situation, it's something you want to know at the outset, and then have it analyzed and have get a sense for what the whether or not you'll be able to overcome it.
Yeah. So let's assume that there's no creditors that do any objections.
Okay.
What's the next step?
Well, the next step would be the second course. Which you can take any time after you file. And then if there's no objections to the discharge, the court will enter a discharge about 60 days after that creditor meeting.
Okay.
So
from the date of application or filing for bankruptcy to the discharge, if there's no hiccups about
I'd say 90 to 120 days.
Oh, I thought it was much longer than that.
No,
okay.
not for Chapter 7. For Chapter 13, which is a sort of a reorganization personally, or a financial restructure of debt for personal or individuals. That's a plan that's going to last 3 to 5 years.
Okay. Can you tell our listeners, the difference between a Chapter 7 and a Chapter 13? Are there some people that can't get Chapter 7 and have to go through the reorganization Chapter 13?
Yes, correct.
Oh, okay.
So there is something called the means test, and it's really a lack of means test. Essentially, the bankruptcy code or the court will look at the last 6 months of income prior to filing and average it and compare it to a household size of the same or similar household size of yours as
Okay.
a median income. So there's a IRS standards that are promulgated. And so I would say probably every 6 months or so, the IRS will put out, or the U.S. trustee, which will use the IRS standards, will indicate what the median income is for a household size in your area. So, and we go by state. So, for a household size of one, I think the median income is $61,000 or $62,000 a year. And then it goes up to 72, 70, or to 74, or somewhere in that range. And so I always look at the table to see where it's at. If you're making more than the median income for the same household size that you have, then you have to do a Chapter 13, which is a payment plan, because the concept is that you can afford to pay something back, right? Okay. And so then it goes to another test, which is a disposable income test. And that essentially applies more IRS standards, spits out a number, and that's the number that you would have to pay back to creditors over 5 years.
And that's why I think it's so important that
right.
if someone's thinking about bankruptcy, they need to talk to you, because it's not just, hey, I'm filing bankruptcy. They need to know if they are filing bankruptcy,
right?
What chapter or what type of bankruptcy are you filing? And
right.
then B, is bankruptcy really the only option?
Right. And so sometimes, like when we were talking before, sometimes I tell people, these are, like I said, these are the options, and you tell them that you have that a bankruptcy is an option, but you're not going to qualify for the quick one. You're going to have to commit, for the next 5 years to this, and that is a commitment, because you have to submit tax returns to the Chapter 13 trustee every year.
Okay.
And if your income goes up, your payment could go up too. Okay. So the goal initially in a Chapter 13 is to get a plan payment based on disposable income, which usually takes about 6 months to get a plan confirmed in Chapter 13. But you propose one from the start. And then try to get your proposed plan confirmed. Then, so the payment's going to end up fluctuating up and down depending on creditors and circumstances, of course. And then you want to get the plan confirmed and then make the plan payment until the last month, and then you get the discharge. So, but it's a commitment, and it's also a situation that's more organic than a Chapter 7. That just looks backwards.
Right.
So Chapter 13 also looks forward.
So when you're meeting with the potential client, and the options are Chapter 7, Chapter 13, but what other options do they have if they're not doing the bankruptcy route? What do you talk to them about?
There's, obviously, as attorneys, our favorite answer is, it depends.
It depends.
But mostly it's try to settle. If there's a means to settle or to work out some sort of arrangement with a creditor, and, that's a feasible resolution to the problem, then I would say do that.
Okay. No, I think that sounds good. And it looks like we do have another question. Ed?
One more from YouTube. Angel looks like wants to know who informs creditors you're filing for bankruptcy.
That's a good question, Angel. Thank you for watching us on YouTube. We appreciate that.
That's a really good question. So when you file bankruptcy, you have to list all your creditors, everybody you owe money to. Doesn't matter who it is. You have to list them all. So
they have to give it to the attorney, and then the attorney has to do the notices to creditors.
Right. So here recently, our U.S. trustee region 21, has been, I wouldn't say they're requiring credit reports, but you have to run one, right? Because
that would make sense. I didn't even think about that, because you may not even know who the creditors are.
Correct. Right. But then on the other hand, there's a lot of things that don't hit your credit report. Like some doctor bills don't hit the credit report, or some of these buy here, pay here's don't hit the doctor or hit the credit report. The guy you borrowed money from down the block, he's not reporting to the credit.
No,
so
true.
It's a combination of the credit report and the information from the individual. But when the case is filed, there'll be what's called a creditor matrix, which is basically just a list of creditors and addresses and their addresses. And every one of those creditors will get a notice from the bankruptcy court saying, this person filed bankruptcy. We're going to have a creditors meeting on this day. You can call in. Here's the number, or it's on Zoom. Here's the Zoom number, or whatever they use, code. And then you have until X date to object to the discharge. So that notice will go out within a day, I would say, maybe 2 at the most, from the bankruptcy court. So
it's the court that actually does it.
Initially, yes. Okay. So a lot of times creditors, though, will find out, from trying to collect from the debtor. They'll call and the debtor will say, look, I filed bankruptcy. And, the first thing a bill collector is going to say, well, what's the bankruptcy case number? If you got one and you tell them, that's the end of the call.
Okay. They can't hound you
Correct.
After that.
That's right.
Is that a violation if they do?
It is. It is. The automatic stay is one of the fundamentals of bankruptcy. It gives an individual or a business a minute to just stop the phone call, stop the harassment, take a look around, see what's going on. Is this going to be a reorganization? Is this going to be a liquidation? It's one of the fundamentals of bankruptcy because, as you know, or as anybody knows, it can be incredibly stressful with the constant phone calls. I've had people just come into the office in tears. Yeah. And even if I say, hey, don't pick up the call, the constant bombardment and activity directed negatively in their direction is a very big stress induce.
Yeah. Now, what happens if we did that list of creditors and then, not on purpose, but another creditor pops up? Can that list of creditors be amended?
Yes. So it can be amended, but you got to remember, in a case like we talked about, that's a typical Chapter 7. You're in and out in 4 months or so, or maybe less. So the window for amendment is pretty short. If it is, a creditor that you really couldn't find, then they're probably past the statute of limitations anyways.
Well, what if it's like that neighbor down the street? You just forgot to say, oh, I forgot that I owed him $2,000.
So you can, if it's a good faith, if you truly accidentally didn't mean to list that person, you can amend the schedule. Occasionally there are circumstances where you could go back and reopen the case.
I was going to ask you that.
Yeah, you can go back, pay a fee, reopen the case, add the creditor. But I think that at some point, you get a year probably past the discharge, maybe, maybe a little less than that. I think at some point you're going to have a trouble reopening a case to add a creditor. Okay. And essentially, if the creditor didn't get notice, constructive notice or otherwise, whether, by mail, sometimes creditors can be noticed just by a commercial on TV, like something in the news. That's constructive notice. Oh, yeah. Okay. For a business, that is. Yeah. Nobody, the regular person's not going to be on the news for filing bankruptcy, right. But, there are other ways to find out. If they weren't able to find out within the time that they were allotted for the objection, then they can come in and their debt may not be discharged.
Okay, that makes sense. And you talked about statute of limitations, and we hear that a lot in our auto cases. In fact, the auto case, they changed it from 4 years to 2 years. You have to file a lawsuit. But how about a medical bill? We hear people saying, "Oh gosh, a doctor or a hospital came, or a collection agency for a hospital came to me, and the treatment was 6-7 years ago."
Right.
dude, what recourse does that person have?
Well, there is a statute of limitations, and it doesn't mean the statute of limitations doesn't mean they can't call you and try to collect. It just means that if they sue you, it's a defense, right? And it's a good defense.
It's a good defense.
It's a really good defense.
Yeah.
So, and it'll probably quash the suit right then and there altogether. And it's basically uncollectible. But essentially, the statute of limitations in Florida for contract or contract debt is 5 years. And it's not from 5 years from the incident or from the date you incurred it. It's typically 5 years from the last time, for instance, with a credit card. It'd be 5 years from the last time you made a payment.
Okay.
Or
yeah.
There's cases that say that it's 5 years from last time you talked to them when you reached out and made an inquiry.
Okay.
So, but typically it's going to be from the last time the payment was made. And it's the same situation for a doctor's office. If you've got a doctor bill that you've been paying $30 on for the last 7 years, and then you stop paying it, your statute of limitations
is from the 5 years from your last payment.
That's right. That's right. Yeah.
That makes sense. And we hear that a lot. I'm just going to give a $5 payment, and they're never going to bother me. They can't sue me. Well, they could sue you.
Yes.
Even if it's $5 a month or $5 a year, they could still bring a claim against you.
That's right. Yeah. So, but and obviously it's also it depends.
Yeah, that's for sure. That's for sure. I know we have still some time, so if people have questions, there's 3 ways to get in touch with us. YouTube has been very popular tonight. Thank you very much for watching us on YouTube.
Yep, Angel, I hope I answered your question.
Yeah, and so Perenich, Caulfield, Avril, and Noyes Injury Lawyers on YouTube, and also Facebook Live. We are here live answering questions that you have too. If you don't want to have your voice on the radio, send us a comment on our live Facebook page. We'll be happy to tackle that question as well. Or you can call us at 727-441-3000. Jake Blanchard is here answering your questions regarding bankruptcy and really providing so much good information for people that are in bankruptcy or even thinking about bankruptcy. And I think that's so important. And I'm here too, Matthew Noyes. I'm one of the partners at Perenich, Caulfield, Avril, and Noyes, the proud sponsors of FLALAW on the radio and the oldest personal injury law firm since 1955. So we are here to tackle questions that you have. But Jake, before I forgot, I also want to make sure that you have some very good information for people after they filed bankruptcy and they've been discharged.
Correct.
What steps should somebody who filed bankruptcy, who's been discharged in bankruptcy, what steps should they have to make themselves have a better future? Well,
I mean, this goes back to the very first conversation we had at the beginning of the show. We were talking about the credit report and the effect of bad credit on someone. I mean, you think about the difference between having a prime percentage rate for a car loan, which I think now it's backed on. If you have decent credit, you can get 4%, and some maybe even lower than that. So take that and compare it to someone with bad credit that is much more of a credit risk, and they go to what's called a subprime lender, and the interest rate is 12, 13, 14%. The interest rate in that circumstance can be so great that the payment for the same car can cost maybe twice, maybe 3 times as much. Wow. So it's expensive to have bad credit. So initially, I try to say, look, you just got out of this mess. Don't be in a hurry to get yourself into that credit card, credit cycle. But, at some point, you're going to want to buy a house, right? Especially if you're young, starting a family. And FHA regulations now say that you can apply for a government-backed mortgage loan 3 years after the discharge. Okay. So that means that gives hope, right? So that means there is life after bankruptcy. But you have to reestablish yourself in your creditworthiness. One of the main ways that I see people do that is if they do have a good loan for a car going into it and they're current on their loan for their car and they reaffirm that debt, that'll help them build their credit faster. Okay. or
Because somebody's going to take your money for a car even after you file bankruptcy.
yes, one way or another.
And so it's important that they take that the creditor,
Mhm.
or I guess not the creditor, the debtor,
Mhm.
as long as he's making pay or she's making payments on that, that's slowly rebuilding the credit.
Yeah, and I mean it does. It really does. The other thing too, which is really I have seen, people get a secured credit card. Will have they'll go into a Regions Bank and get a CD for $1,000 or something similar, or maybe even have a savings account with $1,000. They'll get a credit card, and that credit card is secured by that. And they just use the card to buy groceries or whatever, and then they pay it off at the end of the month. That builds credit pretty quickly as well.
Oh, that's great. So there are ways you can
Right.
build credit after.
But yes,
after you get a discharge, but be smart.
well, yeah. I mean, I mean, do you remember those the after school specials? Like, the kid would go to the park and get some drug from some kid at the park for free. The first one's for free, and then you come back and you keep going back. I mean, that's really kind of how credit is. It can be very addicting.
Well, that's for sure. I know when my son turned 18, we started getting those letters from all the credit card companies in the mail saying.
Yeah, I mean and
I assumed you could do that after you get discharged.
I mean, even after the discharge, you're gonna get offers in the mail. But I mean, it really can be like dealing with drug dealers. I mean, because they make all the money off the interest, obviously, right? And penalties, and it's really always been ironic to me that if someone can't pay their credit card bill, the first thing the credit card company does is double the interest rate. And then give them a charge for not being able to pay it.
Yeah, no, that's crazy. Well, we are about to wrap up. I do have one more question to ask you, but before I ask you that question, I want you to give our listeners your contact information. If they have questions after the show, how can they reach out to you, Jake?
Yeah, sure. My website is www.jakeblanchardlaw.com. Our phone number at the office is 727-531-7068, 727-531-7068. Also, you can email us at info@jakeblanchardlaw.com. That's info@jakeblanchardlaw.com.
Where's your office at?
We are located on 49th Street in the beautiful city of Pinellas Park.
Yeah, it is beautiful. Yes. All right. So the question I wanted to ask you that is often asked and seen on TV a lot, but let's settle it once and for all. Is it ever okay to finance a vacation?
Not if you're my wife.
Yes, I'm sure my wife is probably listening to this too. So do not finance that cruise. But
I don't. I mean, I think that every circumstance is different. But the luxury, financing a luxury is a bit frowned upon in bankruptcy.
And it's gone. I mean, it's an asset. Once a vacation happens, there's no asset to attach to, so to speak.
That's correct. And it's and it adds up quick.
Yes. Jake, I appreciate you taking an hour of your time. I know you're a busy man, family man, and lawyer as well. So thank you very much for taking time. But that does wrap up another edition of FLA Law on the radio. I'm Matthew Noyes. I'll be back next week. But in the meantime, drive safely and watch out for those who don't. Take care.